Hi, I'm Chuck Stull, looking at our next part of intellectual property law, and this is trade secret law. So trade secrets don't have the same kind of long historic protection that patents and copyrights have. This isn't something you can find in the U.S. Constitution, but it is something that has had more attention in recent years. So let's look at that for just a few minutes. In this video, we'll continue our examination of intellectual property law, looking at trade secrets. Trade secrets protect a variety of different things like business plans and strategy, customer lists, current research, formulas, and recipes. And so there are certain famous trade secrets like Coca-Cola's formula or KFC's secret spices. Now, trade secrets, compared to our other areas of intellectual property law, really have very limited protection. Traditionally, this was state courts, but there is a relatively new federal law, the Defend Trade Secrets Act, passed in May of 2016, that allows for lawsuits to be brought in federal court. But it only protects wrongful access to the secrets. Right? So stealing the formula, that would be illegal. Bribing an employee or other kinds of industrial espionage or violation of a non-disclosure agreement, these would all be examples of illegal violation of trade secrets. Right? But reverse engineering is legal. Right? And there is no protection through trade secret law. So I am quite confident that Pepsi-Cola knows the Coca-Cola formula because, a modern science lab with gas chromatography, they could easily identify every ingredient in Coke's formula. And I think the secret spices in KFC's chicken recipe are mainly salt and pepper. But again, any competitor could use a modern lab to find that out and replicate it completely legally. So a trade secret has to be a secret, and that means that the owner has to act in ways to keep it secret. Right? If it is something that is easily available, if they are not working to protect it, then the law won't step in to save them. And the person who gets it must have wrongfully gained access. Right? So again, a spy, an employee who was hired away to disclose the secrets, or someone who had signed a non-disclosure agreement, which they then violated. Trade secrets, because they are just a secret, don't have an end period. I guess they're secret as long as the company can keep them secret. Now, there are some reasons or questions about should this even be a branch of intellectual property law, and why should we give legal protection to trade secrets at all, and particularly why might we push it up from the states to the federal government. And one might be that we'd want to give businesses an incentive to invent or create things that are valuable, but don't meet the standards for patents or copyright. Right? That they're not really creative, that they're not really a new invention, but a customer list is something that would still have a lot of value to that company. Now, there may be some trade secrets that could be patented, but companies might choose not to patent them in order to get longer protection or to save money, right, in order to have lower costs. So in some ways, trade secret protection is longer than a patent, but much weaker. Let me give a fairly well-known example of a trade secret case. And this involves Google's self-driving car through the Alphabet's Waymo division. And there was a big case involving trade secrets that went to Uber. So Anthony Lewandowski was a former Google engineer who allegedly took trade secrets to Uber. So he had worked to develop the original Google self-driving car, the Waymo self-driving car, and took something like 14,000 files, downloaded them before he left Google in 2016. Again, he's alleged to have done that. He then started his own company called Otto, which was purchased by Uber. And in 2018, Google sued Uber for $2.7 billion for the theft of that intellectual material. So the case did go to trial, but the company settled, and Uber gave Waymo, that branch of Google, $245 million in stock, which did leave some questions, some legal questions, unanswered because the case was settled without a court finding. But a really important one was, did Google do all that it could to protect its secrets? And did Uber make sure it wasn't using Google's intellectual property illegally? As an individual, Lewandowski was charged with stealing trade secrets, and he agreed to a plea bargain. He pled guilty to one count of trade secret theft in August of 2020. He was sentenced to 18 months in prison, but because of the pandemic, his prison sentence was delayed, and in January of 2021, in one of his final days in office, President Trump pardoned Lewandowski before the sentence started, and so it is likely we will see him back in the self-driving vehicle business at some point. Let me finish with a clearer example of a violation where there were less questions about it. And this was something that involved the toy business and looking at Mattel. And Mattel created a business unit that's apparent purpose was to spy on its competitors. It was called the Market Intelligence Department, and employees of Mattel would go to trade fairs pretending to be toy retailers, and they had fake IDs, they had tax certificates and business licenses, and then they would go to other manufacturers, to other toy companies, like MGM Entertainment, which made the Bratz dolls, and say, oh, we're a toy store, we'd like information on your new products, how much will it cost them to buy them, when will they be released? And of course, these were not real toy companies, toy sellers. These were employees of Mattel, a competitor, and they would return that information to Mattel, who could then use it for an unfair competitive advantage, by undercutting them on prices or releasing similar products or competing products on similar dates. So MGM Entertainment, maker of Bratz dolls, did sue Mattel for this, who was found guilty in federal court. They were ordered to pay just over $300 million in damages. On appeal, some of those were separated and sent back to state court. The legal battles continued, but it was clearly an illegal venture to get confidential information from a competitor. And so in terms of the trade secret law, it was a fairly straightforward violation. Thanks for listening. This has been Chuck Stull for Law and Economics at Kalamazoo College.